Today we got the decision from the judge that the judge denied the motion to dismiss from the Laundries. So that means that they will be going forward for now on the civil trial. Now, from what J.B. Buno had on, he had on a lawyer this afternoon on WFLA. They mentioned that there's still some more hurdles to go through. So while there is a court date set for August of 2023, we're not completely there yet. So let me go over the article here, and I want to go over the 8 pages that was all the details that were released, as much of it as I can. Like I said, it is 8 pages, so it's pretty long. So let me see what we got going on here. Let's see. Let's cover what WFLA had to say. They released a brief statement, and then, like I said, there was the 8 pages from detailing the what the judge had to say. So this was a release this afternoon. A circuit court judge has denied Christopher and Roberta Laundrie's motion to dismiss a lawsuit filed by Gabby Petito's parents, alleging that they knew their son Brian had killed their daughter. 12th Judicial Circuit Court Judge Hunter W. Carroll ruled the Petito family at this stage had a valid claim against the Laundries and allowed the lawsuit to advance. Brian Laundrie and Gabby Petito were traveling together on a cross-country van trip in July of 2021. Authorities said Petito died 3 to 4 weeks before her body was found in Grand Teton National Park in Wyoming. After an exhaustive search, Laundrie's remains were found in the Carlton Reserve in Northport. Before her body was found, the Laundries released a statement through their attorney saying it was, quote, their hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family, unquote. Petito's parents claimed the Laundries put out a false statement and at the time knew she was dead and where her body was located. Pat Riley, the attorney for Joseph Petito and Nicole Schmidt, said that while the ruling doesn't guarantee a trial next year, it significantly increases the likelihood of the lawsuit reaching the trial phase. Again, there's some more hurdles to go through here. I'd say it's more than 50%, Riley said to WFLA about the chances of a trial. In their motion to dismiss the suit, the Laundries claimed that they had, quote, fundamental constitutional rights to silence, unquote. But the court ruled it was, quote, not, quote, necessary or appropriate in this case to resolve those constitutional claims on a motion to dismiss, unquote. Quote, the contours of the facts are not significantly distilled to apply those important guarantees. Those claims are more importantly addressed, if at all, at the summary judgment stage, unquote, the court order explained. Quote, if the facts of this case truly were about silence with no affirmative act by the Laundries, the court would have resolved this case in the Laundries' favor on the concept of legal duty, or more precisely, the lack of any legal duty for the Laundries to act. Had the Laundries truly stayed silent, the court would have granted the motion to dismiss in the Laundries' favor, unquote. Quote, as alleged by the plaintiffs, the Laundries made their statement knowing that Gabby was dead, knowing the location of her body, and knowing that her parents were frantically looking for her. If this is true, then the Laundries' statement was particularly callous and cruel, and it is sufficiently outrageous to state claims for intentional infliction of emotional distress, unquote, the court order said. The Laundries made additional arguments in their motion to dismiss the suit and argued that denying the motion would result in a, quote, avalanche of litigation, unquote, for people in similar situations. The court said that argument missed the mark. Quote, there will be no avalanche of litigation based on denying the Laundries' motion to dismiss, unquote, the court order said. None of the additional arguments are sufficient to preclude the court at the motion to dismiss stage from concluding that the amended complaint states causes of action for intentional infliction of emotional distress, unquote. In a statement to WFLA Now, the Laundrie's attorney, Stephen Bertolino, said the couple was, quote, disappointed with the judge's decision to deny the motion. Quote, Judge Carroll points out that the September 12, 2021 statement, standing alone, does not suggest outrage, but within the context of the other allegations in the case, though the plaintiffs have met the threshold to go forward to the next phase, unquote, Bertolino said. The Laundries will continue, quote, the Laundries will continue to use all available legal means to preserve their rights, unquote. So that's basically the summary that WFLA put out. But the bottom line is, as of right now, we're going forward. So the Petito Schmidt lawsuit versus the Laundries has passed this stage. But like I said, there's more to go. I mean, while this is awesome news, I mean, I was really thrilled. There is much more to go, and I'm hoping that it'll continue to go well for the Petito, the Schmidt family. So there is, like I said, there was 8 pages detailed from the court today that were released. They're quite extensive. So let's see. I'm going to post them here as well, but actually I'm probably going to just post a link to them because they're hard to read when I just share them here. Let's see. They're dated today, and it's signed by Hunter Carroll, Circuit Court Judge. On 6/30/2022, the court caused the foregoing document to be served via the Clerk of Court case management system, which served the following individuals via email, and in parentheses it says where indicated. On the same date, the court also served a copy of the foregoing document via first-class U.S. mail on the individuals who do not have an email address on file with the Clerk of Court. Let's see here. They caution that the allegations of the fact of the court will discuss below are simply that, allegations, and not proven fact. Okay. In July 2020, Brian and Gabby became engaged to each other. The following year, in July 2021, Brian and Gabby left New York in Gabby's van, headed west for a, quote, van life trip that was to last several months. Gabby intended on documenting her trip and publishing her journey on various social media sites to establish herself as a travel influencer. Gabby regularly called her family while on the trip. Gabby's last communication with her father occurred on August 21st, 2021. Gabby's last communication with her mother occurred on August 27th of 2021. Brian murdered Gabby on August 27th, 2021. Brian then texted between his and Gabby's phone to hide the fact that Gabby was dead. Brian would continue to send texts from Gabby's phone until at least August 30th, 2021, in which Brian disguised as Gabby texted Gabby's mother stating there was no service in Yosemite Park. So that's been, supposedly these are allegations here. Let's see. Brian did this to suggest that Gabby was still alive. Gabby was 22 years old at the time of her death. On August 28th, 2021, Brian told his parents that he murdered Gabby. And in parentheses it states, the court must assume this to be true for this motion. That same day, Christopher and Roberta spoke with an attorney, and they would send the attorney a money retainer several days later. That same day, Christopher and Roberta spoke with an attorney, and they would send the attorney a money retainer several days later. On September 1st, 2021, Brian returned to his parents' home in Northport, Florida, driving Gabby's van. Brian and his parents then vacationed together at Fort DeSoto Park on September 6th through 7th, 2021. They took this vacation each knowing that Gabby was dead and that her parents were frantically looking for her. On or about September 10th, 2021, Roberta blocked Nicole on Roberta's cell phone and on Facebook. On September 14th, 2021, and fully knowing that Gabby was dead and knowing the general whereabouts of Gabby's body, the Laundrie's attorney released the following statement. Now, this is very key for why this got through. It is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. That's their mistake right there. They wanted to remain silent, but that's what's right now. That's what's got this continuing. On September 16, 2021, the attorney for Gabby's family issued a letter to Christopher and Roberta, which provided, "We are writing this letter to ask you to help find our beautiful daughter. We understand you're going through a difficult time and your instinct is to protect your son is strong." All right, let me get to the next page. "We ask that you put yourself in our shoes. We haven't been able to sleep or eat and our lives are falling apart. We believe you know the location of where Brian left Gabby. We beg you to tell us. As a parent, how could you let us go through this pain and not help us? As a parent, how can you put Gabby's younger brothers and sisters through this? Gabby lived with you for over a year. She was going to be your daughter-in-law. How can you keep her location hidden? You were both at Jim and Nicole's house. You were both so happy that Brian and Gabby got engaged and were planning to spend their lives together. Please, if you or your family have any decency left, please tell us where Gabby is located. Tell us if we are even looking in the right place. All we want is Gabby to come home. Please help us make that happen." Christopher and Roberta declined to respond to either Joseph or Nicole, instructing all communication to be made through their attorney. The attorney would issue a, quote, "no comment" when asked about Gabby. They did this knowing of Joseph and Nicole's mental suffering, and by advising where Gabby was, they could quote, where Gabby, they did this knowing of Joseph and Nicole's mental suffering, and by advising where Gabby was, they, quote, "could prevent such additional mental suffering and anguish of Joseph and Nicole by disclosing what they knew about the well-being and location of the remains of Gabby, yet they refused to do so," unquote. Admit culpability. Let's see. Continuing, Joseph and Nicole further allege that Christopher and Roberta, quote, "acted with malice or great indifference to the rights of Joseph and Nicole," unquote. Okay, analysis section here. It says plaintiffs sued the Laundries for intentional infliction of emotional distress. Florida recognizes tort Liberty Mutual Insurance Company versus Stedman 968 SO 2nd 592 594-95 Florida. I'm not going to read all that, you guys. DC 8 2007. Eternal quotations, citations, and footnotes omitted. Okay. The question for today is whether plaintiffs stated causes of action for that tort. 1. A note about legal duty. Laying aside for the moment the statement the Laundries made through their attorney, the other conduct plaintiffs complain of mostly involves the Laundries failing to act. Specifically, plaintiffs seek to fault the Laundries for not telling the plaintiffs that Gabby was dead or where her body was located. The Laundries framed their silence in constitutional terms, arguing that their silence was constitutionally permissible under the First, Fifth, and Sixth Amendments to the United States Constitution and related Florida Constitution provisions. The court does not believe it is necessary or appropriate in this case to resolve these constitutional claims on a motion to dismiss. The contours of the facts are not sufficiently distilled to apply those important. Okay, next page. All right. Hold on. Those important. those important guarantees. Those claims are more appropriately addressed, if at all, at the summary judgment stage. Plaintiffs, during oral argument, candidly conceded that they struggled with the legal duty owed by the Laundries to them that would have required the Laundries to break their silence. Plaintiffs appear to conflate morality with legal duty. Plaintiffs have not identified, and the court is unaware of any legal duty the Laundries would have owed to the plaintiffs to tell the plaintiffs that Gabby was dead or the location of her body. Further, the plaintiffs point to no duty that the Laundries were under to accept text or social media messages from the plaintiff or to refrain from taking a vacation while the plaintiff searched for Gabby. If the facts of this case truly were about the silence with no affirmative act by the Laundries, the court would have resolved this case in the Laundries' favor on the concept of legal duty, or more precisely, the lack of any legal duty for the Laundries to act. Had the Laundries truly stayed silent, the court would have granted the motion to dismiss in the Laundries' favor, but they did not remain silent. Okay, that is the key right there. Okay, that is the key right there. Because this is long, I'm going to have to take a drink. Sorry, guys. That is the key, that they did not stay silent. Because of their statement through their attorney, which was previously mentioned at the beginning, because they said, we hope that she returns home to her family, that totally just like bit them in the butt right there. And if they would not have stated that through their attorney, Stephen Bertolino, they might have been able to get this dismissed. That's what the judge is saying here. Okay, 2, the Laundries spoke. The Laundries attorney released a statement that plaintiffs argue was outrageous under the facts of this case. Plaintiffs sufficiently alleged that the Laundries spoke. Quote, Christopher Laundrie and Roberta Laundrie, through their lawyer, issued the following statement. In oral argument, the Laundries contended that there was no allegation in the amended complaint that their attorney knew that Gabby was dead or the whereabouts of her body when he released the Laundrie statement. That position is meritless for at least 3 reasons. First, generally, an attorney serves as an agent for his client. The attorney's acts are the acts of the principal, the client. Second, all facts and reasonable interferences are construed in the favor of the non-movement, here the plaintiffs. A reasonable interference is that the attorney knew the same information that the Laundries knew. Third, that the words used in the statement indicated that the Laundries agreed to it. It provided, quote, our understanding, end quote, on behalf of the Laundrie family, it is our hope, on and on. Certainly there is no allegation in the amended complaint that the Laundries disavowed the statement. So that basically is explaining why they did not remain silent. For the purposes of the motion to dismiss, the court must assume that Laundries are responsible for authoring the September 14th, 2021 statement issued by their attorney. The statement. The Laundries contend that their statement is not outrageous as a matter of law. At oral argument, they suggest it merely was a plain statement. Plaintiffs, in contrast, countered during the oral argument that the statement knowingly was false, designed to create false hope and issued by the Laundries, who knew that Gabby was dead and where her body was located. The elements of the intentional infliction of emotional distress tort and contours that have been described by the 2nd District Court of Appeals as follows. To state a cause of action for intentional infliction of emotional distress, a complainant must allege 4 elements. 1. Deliberate or reckless infliction of mental suffering. 2. Outrageous conduct. 3. The conduct caused emotional distress. And 4. The distress was severe. Behavior claimed to constitute the intentional infliction of emotional distress must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. In applying that standard, the subjective response of the person who is the target of the actor's conduct does not control the question of whether the tort of intentional infliction of emotional distress occurred. Rather, the court must evaluate the conduct as objectively as is possible to determine whether it is atrocious and utterly intolerable in a civilized community. Whether conduct is outrageous enough to support a claim of intentional infliction of emotional distress is a question of law, not a question of fact. And they are quoting Stedman, some other court cases here. I'm actually going to skip this part, but like I said, I'm going to include this for you guys to read. Actually, on page 6, actually just goes over more of the restatements and talking about torts, and I'm not even close to an attorney or anything, so there's some better folks on YouTube for that. But let's see here. Reinstatement, they go through the torts. Okay. The words, the words used by the Laundries on the surface initially do not suggest outrage. On behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. When juxtaposed with the other conduct in this case, though, the outrageous threshold is surpassed. As alleged by the plaintiffs, the Laundries made their statement knowing that Gabby was dead, knowing the location of her body, and knowing that her parents were frantically looking for her. If this is true, then the Laundrie statement was particularly callous and cruel, and it is sufficiently outrageous to state claims for intentional infliction of emotional distress. The court identifies 2 additional cases that support the court's decision, although neither were necessary for the court to conclude the amended complaint stated causes of action. Consistent with the comment, the court notes that Florida law recognizes that family members are particularly susceptible to emotional distress around the time of a loved one's death. Malicious conduct during this time frame can rise to the level of outrage. Okay, there's 2 previous court cases they note here. There's in Thomas versus Hospital Board of Directors of Lee County and Williams versus City of Minola. So that is page 6. Okay, page 7. These cases confirm the court's conclusion that the plaintiff's amended complaint stated causes of actions against the Laundries. So those 2 cases that they're stating, which you guys can read, are giving some examples. Okay, there will be no avalanche of litigation. This is what the Laundries are stating. The Laundries argue that denying their motion to dismiss will result in an avalanche of litigation for situations where relatives of tort victims receive bad news about family members. They base their argument on, and there's some court cases listed here, the Laundries' argument misses the mark. In MM, the tortfeasor told the parents of the victim that the tortfeasor had sexually abused their daughter and the tortfeasor's wife had supplied illegal drugs to their daughter. The parents sued the tortfeasor based solely on their distress from the tortfeasor's disclosure to them, and the daughter separately sued the tortfeasor based on the tortfeasor's sexual abuse. The 3rd District held the parents had no cause of action under those facts. That court remarked that receiving bad news about family members was insufficient for a claim where there is no attendant intentional or reckless conduct directed toward them. The court has no quarrel with that holding, and in fact it is consistent with the court's decision today. The facts of MM simply are distinguishable because there were no facts in MM suggesting the tortfeasor directed any conduct toward the parents. Here, plaintiffs allege the Laundries issued a public statement of false hope, knowing Gabby was dead and the location of her body, while Gabby's parents frantically were searching for her under mysterious circumstances. The 2 factual scenarios are readily distinguishable. There will be no avalanche of litigation based on denying the Laundries' motion to dismiss. Okay, and a parting thought. The court is aware the Laundries have made additional arguments in their filings and at oral argument to support their motion. The court need not to detail all these except to say none are sufficient to preclude the court at the motion to dismiss stage from concluding that the amended complainant states causes of action for intentional infliction of emotional distress. The Laundries' motion to dismiss is due to be denied. It is therefore ordered. 1. Defendant's motion to dismiss the amended complainant is denied. 2. The defendant, Christopher Laundrie, and defendant Roberta Laundrie shall answer the amended complaint on or before July 15th, 2022, done in order in Venice, Sarasota County, Florida on 6/30 of 2022. So I believe that's it, and it's the last page I think is just the signature. So that is the statement. It's long. So, but the bottom line is they got denied, and it's really good news. So it gives a chance for the Petitos and Schmidts to move forward in this process. And from what I'm hearing, the attorneys are stating it's going to be long. So there's no way that this is going to go to trial. If it makes it to a jury trial, it's not going to happen until at least August of 2023. It may even be 2024. Not only because it takes so much time to prepare, if they can make it through any further things that come through. And if we get summary judgments, apparently they come through, and other sorts of things from there. But we're definitely not, if we get a trial, they're stating that we're not going to get one till at least the August 2023 date that was previously already set up for the civil lawsuit to take place. So, but this is good news, and I know I was very happy to hear it, because I really do believe that while we can't bring any, Gabby back, this is the best justice. If we can get all this to come out, this is the best justice that we have for Gabby, and most of all for her family. So hopefully Nicole and Joseph and the rest of the family, they can get some kind of a closure off of this. I mean, I know they're suing for money, but I believe the money would go to the Gabby Petito Foundation. I don't believe that it's for them, it's about the money. I think they want the answers, they want accountability, which I agree it should happen, because unfortunately I don't believe any criminal charges are going to come from this, because Brian's dead, and Roberta and Chris, I don't think they're going to charge them, because the FBI hasn't up until now. So any money they do get, if that happens, from a judgment or from winning a jury trial, would more than likely go to the Gabby Petito Foundation, which I'm actually wearing the bracelet right now. I'm a big supporter of the Gabby Petito Foundation and Justice for Gabby. And I'm actually wearing a shirt that was made by someone else during the early stages, and well, I believe they were still looking for Brian. Unfortunately, I believe that she was passed at that point. And I got my my butterflies on as well. So I'm all about justice for Gabby, and I'm going to continue to follow this until it's over, whatever that means. In the meanwhile, like I said, I will post the links to the documents, so you guys can read them in full if you want to actually look at them. They're going to be hard to read on the screen where I stick them, so, and they're hard enough to read as you zoom into them, but, because I think they're copies of a copy. But, I mean, like I said, we have good news. We're ending the week right before the holiday weekend with some good news, and I'm praying for Gabby's family at this hard time, and, yeah. One more thing I did want to go over was that the attorney for Gabby's family did make a statement today. Let me pull that up here. So the attorney, Pat Riley, did release a brief statement after this ruling today. And it states, Joe Petito and Nicole Schmidt, the parents of Gabby Petito, are appreciative of the thorough and well-reasoned decision of Judge Hunter W. Carroll, which denied the motion of Christopher Laundrie and Roberta Laundrie to dismiss the complaint filed against them. This gives them an opportunity to proceed with their claim for emotional distress caused by the conduct of the Laundries. Joe and Nicole look forward to discovering the information the Laundries knew about Gabby's death and her whereabouts, and in particular, getting a copy of any correspondence, emails, and texts exchanged during the difficult period when Gabby's whereabouts were unknown. They look forward to going to trial and are confident that ultimately the Laundries will be held accountable. At this time, Joe and Nicole do not wish to discuss the matter publicly and ask for you to respect their privacy. So that is their statement, and I believe they really do deserve their privacy. So they'll speak up again, probably through their attorney, or if they want to post anything on their socials, I'm sure they will do that when they feel ready. But like I said, we're in the right direction here, and I believe that this judge was very fair in his ruling. So we'll see where it goes from here. What do you guys think of this ruling today? Are you hopefully looking forward that this all continues to, go through its cycle and we eventually do get a jury trial? I really do hope we get a jury trial, because I would like to see all this evidence. And I believe, like I said, I think that the family wants to know more of the evidence than they want the money. So obviously the money will help the foundation, but they want to just find out the truth. And that's the bottom line, I believe. They just want to find out what really happened. And this family, I believe personally, not only did Brian, I believe that he killed her, and I don't buy that notebook story one bit. I believe that Mom and Dad knew. Mom and Dad Laundrie knew. I believe that he told them. He came home and he told Mom and Dad what he did, or he called them on his way home and told them. So I believe they know a lot more than they've said, and I really would like to see them held accountable and sit up there, and they have to tell everybody in open court what happened. So what they know. Alright, so that's going to be it for today. I really do appreciate you guys checking out the channel. On your way out, if you like the content that you're seeing, please hit that like button, that thumbs up for me, and hit subscribe. I really do appreciate it. And with that said and done, have a good one, guys, and stay safe.